Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to murthy.com for contact information. From the beginning, Murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The Murthy.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the H-1B FAQs, and we will continue the knowledge session along with the last week's Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Murthy.
Hi, good evening to you, Thorny, and good afternoon to all of you here in the US. Honored and delighted to be here to answer your questions, to explain immigration laws, to continue to educate, enlighten, and empower each and every person that is going through the immigration process. And if you're an employer, to educate and empower you as employers so that you continue to embrace and recognize the fact that America is such a great country because of the contributions and the value that immigrants bring, because at the end of the day, we are a nation of immigrants. Thank you.
Right. Welcome back, Ms. Murthy, and very well. We hope you're doing well as well. So we already have a caller before we begin with the topic this week. So Mr. AJ from San Diego, thank you for calling, Mr. AJ. I'll put you right through to Ms. Murthy and you can ask her your question directly. Hi, Mr. AJ, are you there?
Can you hear me?
Right, we can hear
yes,
you now.
Ajay,
You may ask Ms. Murthy your question directly.
Perfect. Hi, good afternoon, Sheela Murthy. This is AJ from San Diego. I have a question. So it is related to H-1B question, but just bear with me. So I filed my 140, the first one in 2010. My priority date is 2000, and then I changed the company in 2018. So they filed everything. I-140 came in, and then we reported the priority date. Now, I-45 is filed, and then 6 months has gone, okay? But now what is happening is our company is going to take over by other company, so there's chance of a layoff. So my question to you is, they extended my H-1B last year for 1 year only till May of 2022. So what's my chances of going to H-1 or EAD hasn't come yet? So I'm just expecting my EAD next month or something. But what are the chances for H-1B refiling and for the new job?
So Ajay, it's not a big deal, right? If you have a I-140 petition that was previously approved, as long as you're able to find any kind of employment or an H-1B employer that is willing to sponsor your H-1B, if let's say the new merged entity decides not to continue your H-1, then all you need to do is have the new employer file the H-1, and based on the I-140 approval, because it was valid for over 180 days, you can actually obtain potentially a 3-year H-1B extension with any new H-1B employer, as long as they're willing to offer you the job and sponsor you for the 3-year H-1 and your priority date is not yet current. Then it's not a big deal. You're certainly eligible to file the H-1B extension of status in 3-year increments. And if the same employer agrees to continue your H-1 and your green card process, then very well, you may decide you want to do that, because that way you don't have to start a fresh green card with a new employer. But you very well may be able to continue the green card with the new employer. You can certainly port the priority date even if you change jobs and employers. But your voice broke up in a couple of places, but if your 485 was also filed, then as you well know, under the AC-21 Adjustment of Status Portability provisions under the AC-21 law, which is the American Competitiveness in the 21st Century Act passed in October of 2000, under that law, you will be able to continue even the 485 and the green card process based simply on being able to establish and show that the new job duties are same or similar to what was filed in your original perm and I-140 application. But if the 485 was not filed, then obviously you can just use the priority date, start a new perm and I-140 with a new employer, or if the new job is completely different, you would need to do a fresh perm, fresh I-140, but port that priority date, which is extremely beneficial for people born in India, for Indian nationals. I hope that was helpful for you, Ajay, and good luck.
Right. So, Ms. Murthy, we have another caller on hold, Ms. Radha from Virginia. Thank you for calling. Radha, you may ask Ms. Murthy your question directly.
Hi. Good afternoon, Murthy.
Good afternoon, Radha.
I have a question related to H4 EAD automatic extension. So I just want to check if I'm eligible for that clause or not. So I have applied for my H4 and H4 EAD together on March. My previous H4 expired on August. And my latest petition got approved, like only H4 got approved this October. There was a gap between the previous H4 and the new H4. So, but still my H4 EAD is pending. So am I still eligible for that auto extension or no?
So it sounds like you should be, Radha. Let me understand. You said your H4 extension of status was approved until October of 2021 or until October of 2022 or 23? I wasn't clear.
Yes. So my recent H4 application was approved till August 2024.
Oh, fantastic. Congratulations.
Here is still pending. Mm-hmm.
Okay, so now you are eligible under the new rules, because you should be eligible, because you need to only satisfy, it is the earlier of one of the two, that one of the criteria, right? You have to file the extension prior to the current status expiring, which you did, because your EAD was only expiring in August and you applied in March. Second, it says that your H4 status should still be valid because it's the earliest of the three. It should be valid. In your case, it is valid because your H4 extension was approved until August of 2024 for 3 more years. And you are granted automatic work authorization for at least 180 days. So you should be allowed from August onwards, September, October, November, December, January, February. So at least till February of 2022, it appears that you should be eligible for the automatic employment authorization based on the fact that your status was extended incident, that the EAD is based incident to your status, and you have filed the extension and it should be approved. Did you talk to your company lawyer and discuss it with whichever the employer you're working with, and what have they explained to you, Radha?
Yes, ma'am. So they were also saying the same thing, but a few of the attorneys, I've been talking to so many people. So some of them said, because I have applied my H4 and H4 EAD concurrently, so I am not eligible for that. So that's where, I'm seeing mixed results from different people. So I thought, you're good, my most reliable source. So a lot of people asked me to connect with you. So I saw today's channel and, I'm calling you.
Okay. So Radha, the way I look at it is, if the company and the company's lawyer, because they are, as an employer, they are equally liable and responsible if they make a mistake or they give you wrong advice. If they are willing to say, Radha, I think you're fine, we are going to allow you to continue to work and pay you a salary, I don't know that I would try to talk to 10 other people and get 10 conflicting opinions unless somebody is going to pay you a salary for that job, right? Your company and company's lawyer have agreed to help you and agreed to continue the process for you, right?
Thank you so much, Murthy. So it's really, really happy news for me. Thank you so much. I'll talk to my employer and take it further.
Good luck. All the very best, Radha. And happy Thanksgiving to you and yours as well.
Yeah, same to you. Thank you.
And you continue to spread smiles, Ms. Murthy. So we have another caller. Mr. AJ is back on the call. He has something else that he wants to ask. So thank you for calling again, AJ. You may ask Ms. Murthy your question directly.
Hey, this is Murthy. So what I want to say is like my 485 is pending for 6 months and EAD hasn't come yet. Okay, and so the layoffs might be happening in January, not like I have a couple months. So like if the EAD doesn't come through and if I join a different company, then they have to file my I-140 and everything again.
Did you say your I-485 is already filed and filed for over 180 days?
Yes.
Okay. So as long as the new job duties are same or similar, Ajay, as we said before, then you can take advantage of the AC-21 adjustment of status portability provisions and not have to refile the entire green card from scratch.
Okay. Even if the EAD doesn't show up.
So the EAD is only an employment authorization document that is incidental to filing the 485 application. The EAD allows you to work with other jobs or other employers. So the getting or not getting the EAD or delaying the EAD issuance does not have anything to do with being able to take advantage of the I-485 pending AC-21 adjustment of status portability provisions, which under the law passed back in October of 2000, 21 years ago, allows you to change jobs or employers as long as the new employer files the supplement J, sends it to the USCIS, shows them that the job duties, that the new job is identical, same, or similar. And that is to continue the green card. But you cannot work on that. You have to work based on filing an H-1B. If you have the EAD, of course, you can work based on the EAD. But if you don't have an EAD, then you have to file it. You don't have to get an approval from the new employer. You just file a change of employer petition, that what we sometimes we use the language called transfer, but it's a new H-1 petition. It's a transfer to a new employer. File it, and based on the pending petition, you can legally start working on the day that they file it, and hopefully they can file it within 2 weeks as soon as they get the prevailing wage and the LCA certified, which takes about 2 weeks. So you should be able to start working right away and let the EAD take its own sweet time, because it is taking anywhere, as we know, from 2 months up to 13 months to get issued. But once the EAD is approved, then you can use that if you don't wish to stay on H-1 status. We usually recommend H-1 because it's always helpful to have a backup status, Ajay.
Yes. Thank you very much, Murthy. Because somebody told me that I cannot change the job right now because my H-1, there is like, because my priority date is current, so they only extend for 1 year or something like that. So that's the confusion. That's the confusion part.
It is true. So if the priority date is current, as I mentioned earlier, a person is only eligible for 1 year H-1B extensions of status instead of 3 years, which is probably, I wasn't sure, but that could have been the main reason why the company lawyer only filed the H-1 extension for 1 year for you instead of 3 years, as you just mentioned a few minutes earlier, because if the priority date is current, you cannot get a 3-year H-1 extension by law.
So for the new company will file for 1 year only?
If the priority date is current, you're eligible 1 year. If the priority date is not current, a lot of priority dates that were current in October 2021, this month in November, are no longer current. So if that is the case, then you can ask and get full 3 years.
Okay. If it is current, then only 1 year. Okay. I got it. Thank you very much. Okay.
Sure.
Right. So, Ms. Murthy, could you tell us what the immigration updates are for this week? We finally got at the topic now.
Yes, absolutely. Good. It's always a pleasure. So I know that Radha asked a question about H4H for dependent spouses. Of course, this is a fairly new rule. There is, as always, there are some restrictions. There's some confusion. It's not as clean for H4 dependents as it is for L and E dependents. the L2 people on L2 and the dependents on E status because their rights and are based on the law passed by Congress, whereas the H4 dependent spouses eligibility for employment authorization is based on the Department of Homeland Security regulation. And because of that, the H4 dependent spouses need to meet the test of not just being on H4 status, but also filing the EAD extension, and that it should be pending and it's valid for the earliest of one of the three that we went over a few minutes ago. So that is one of the latest changes that we have seen. Also, the earlier this week, yesterday, I believe, the US Department of State issued the visa bulletin with the movement of priority dates. And I'm sure many of our viewers have already noticed that the priority dates have moved for EB2, but EB3 has not moved. And so I think people are starting to get nervous about the EB3 that could potentially continue to retrogress or move much slower. And will EB2 move much faster? And should I now continue? And even though I had filed a downgrade application 1 year ago in October 2020, should I now file another EB2 interfiling with the pending 485? But in general, the philosophy is please wait until the final action dates are current in EB2 to interfile it. And that way you are not just, changing each time and confusing and delaying your own 485 approval with the USCIS, because if they're not sure which one to use, they might issue an RFE. In general, the USCIS is supposed to approve the I-485 based on any eligibility, even of a different I-140 petition that is approved in your name. So for example, if you have an EB2 and an EB3, the USCIS technically, according to their policy memo and guidance, should be approving the 485 based on the EB2 case, even if interfiling is not requested. We generally suggest interfiling only when the final action date is current, so that the USCIS can then sort of pull it out and do it either directly or because they are being sent another reminder. Thank you.
Right. Thank you for the updates, Ms. Murthy. So we have another caller on hold, Mr. Kumar from Texas. Thank you for calling, Mr. Kumar. You may ask Ms. Murthy your question directly.
Hi, Murthy. How are you? I just
Hi,
have
Kumar.
one question.
How are you?
Yeah, thank you. I just have one question. This is related to the changing job after receiving the green card. I'm more concerned about what is the intent of and future position, that what kind of issues can come during naturalization. Thank you.
Okay, Kumar. So you're saying about changing jobs or employers and not staying minimum 6 months to 1 year after the 485 approval with the green card sponsoring employer. Is that your question?
Yes.
Okay.
How soon we can change the job of green card? And I've been working for this company for more than a long time, like 6 to 7 years. So I just wanted to know what are the things that I have to take care of.
Yeah. So, in general, I think part of the problem, or the way the law is written, is that green card is based, the perm and the I-140 and the entire green card process is based on the concept of a future job offer, unlike the H-1B, which is based on the current job offer. So when the employer files the perm and I-140 and you file your 485, Kumar, you signed under penalty of perjury under oath, and the employer also signed documents under penalty of perjury, which is why we say it's a federal criminal offense, to say that once Kumar's green card is approved, I will promise to offer a permanent full-time job for Kumar to work on a full-time and permanent basis with my company. And Kumar agrees to stay in that job forever, basically, on a full-time and permanent basis after the 485 is approved. Now, if a person is leaving the employment, it's okay as long as you file the supplement J with the USCIS, because now you have notified them that I am switching from employer A to employer B, and it's the same or similar job. However, if no supplement J was filed and no notification was provided, but the employee decided to quit Now, it's a different issue if the employee quit because the company shut down, the person was fired, there was a merger acquisition, and there were layoffs. But if the employee just quit, then the question becomes whether there was valid good faith shown by the employee consistent with the law in agreeing to work on a permanent and full-time basis with the employer. And where we see the problem, Kumar, generally showing up, of course, is at the time of filing the N-400 for US citizenship, because that is where we see that the USCIS examiner or officer will say, okay, when did you leave? Why did you leave? What happened? And then they investigate it, and they not only potentially could deny the citizenship, but they could potentially harass or threaten that the green card itself was improperly approved because it was based on both the employer and the employee agreeing to work on a full-time and permanent basis after the green card is approved. So that's where the risk is.
So can I work like 3 months and then would that be okay, or would there be any minimum time?
So we usually tell people 6 months to a year. You could do 3 months, you could do any amount, but the lesser and lesser the time is, the more and more it looks like you're not complying with the permanent, because the law requires permanent full-time position with the employer, right? So I think that's where the question is. And so the question is, you waited 5, 10, 15, 20, 30 years to get the green card, Kumar. Would you jeopardize it for 3 months? Would you take that risk? So I tell people, at the end of the day, we all take risks, but what risk are you willing to take? And how long are you willing to look over your shoulder to see if the government is coming after you?
Sure.
All the best.
Thank you, Murthy.
Right.
You're welcome.
That was brilliant, Ms. Murthy. I'm, as usual, in awe of your answers. Right.
Oh.
So we have another caller on hold, Mr. Gopichand. Thank you for calling, Gopichand. You may ask Ms. Murthy your question directly.
Yeah, thank you. So I just one question. I did approve I did apply my I-140 last year. My priority date was around July 2020, and my I-140 got approved last week. And but there is a section in the I-140 consulate. In that consulate section, I see there is a NVC mentioned, but many of my friends, they don't have anything mentioned in that consulate field.
Yeah, I'm not sure why your employer or you asked for your I-140 to be consular processed with the National Visa Center with NVC and sent to probably the US consulate in Delhi or Mumbai in India, because either you're out of status or there was some gap, or there's a family member that's stuck and you wanted to do 485 instead of doing adjustment of status 485, you wanted to file your green card through adjustment of status instead of adjustment of status within the United States. You wanted to get your green card from abroad through the consular processing route or the NVC route. At least that's what it looks like based on what you're telling me.
Mm-hmm. So do I need to take any action at this moment? I mean, it will not affect my H-1B after 6 years, right? So still I'm eligible to get that extension, right, after 6 years with this current approved I-140?
Yes, there is no restriction whether you're doing consular processing or adjustment of status. As long as the I-140 petition has been approved, the law allows, and the priority date is not current, then the law allows for 3-year H-1B extensions in 3-year increments indefinitely. As we discussed earlier, if the priority date is current, then the employer is only eligible to file for 1-year H-1B extensions of status for the individual under the law. So the fact that it was requested with NVC or consular processing instead of filing adjustment of status in the US, and whether that was requested because of a particular strategic reason or a mistake or an oversight by the employer or the attorney, that's something you need to discuss. If it was a mistake, you are eligible, and a person could potentially, when the priority date becomes current, or the final action date or the date of filing, a person can still file the I-485 within the United States. And so then the USCIS will have to request the file to be returned back from the NVC back to the USCIS so that they can adjudicate and process the 485 within the United States.
Okay, got it. Thank you. Thank you so much. Have a nice.
You're welcome.
Right. So, Ms. Murthy, as long as we're on the I-485 topic, what kind of I-485 RFEs are we looking at right now?
So remember, the I-485 is the third and final last stage in the three-step green card process. Stage 1 for most people who have labor certification is the PERM, where you show the U.S. Department of Labor there's no ready, willing, and qualified worker to do the job. Stage 2 is the I-140 petition, where the employer is sponsoring the immigrant petition for the foreign national worker. And the employee is showing the education, the degrees, the qualifications, the work experience with the letters, etc. Third stage, adjustment of status of 485, is where you're adjusting within the United States from non-immigrant to the immigrant status. And you need to establish that you don't have a communicable health disease, you don't have a criminal record, you don't have any of the conditions that would make a person inadmissible to be admitted or to become a permanent resident, a lawful permanent resident or LPR of the United States. So what are the reasons for an RFE to be issued? Well, if you have a criminal record, they will ask for documents and proof. If you even have a small citation, like a traffic violation, you're supposed to check that off under the revised and newest versions of the 485 form. If you have any other criminal, whether it's shoplifting, DUI, solicitation, any of those unfortunate things that happen in life, remember that you absolutely need to check it off and say yes, and that could result in the USCIS calling you in for an interview to ask additional questions, etc. We tell people all the time, mistakes happen, that's part of human nature. We all have made mistakes in life. No human being is perfect, but what really can upset the USCIS and result in the denial of the I-485 is if the person says, well, I don't need to mention it because it's a traffic ticket and I already paid the fine, or I don't need to say this because I got my file is now closed. The judge, issued a decision. The judgment is closed. I even got an exoneration, or it's been cleared from my record. There's an expungement in my record, but it doesn't matter. Under the 485 law, you are required to mention and divulge that information, even if there was a complete expungement. And under state law, the state criminal lawyer who may have helped you with your case may say, you don't ever need to mention that for the rest of your life. That's true for an American citizen, but for those who are not citizens and who are going through the US immigration process, you have to say yes, even after an expungement, because that's what the law requires. And if you don't do that, then not only can you get an RFE, but you could potentially get a denial of your 485 application for, again, it's a violation. Remember, I mentioned earlier, we all sign documents under penalty of perjury, whether it's employer or employee or the individual. And so if they consider that as a penalty of perjury criminal offense, that would prevent the USCIS from issuing the 485 approval. So it's a very serious matter. You have to be, divulge the information. And most times, as long as it's within, it's not considered an aggravated felony or certain definitions. Again, remember there are federal law components to immigration and criminal laws, and state law issues with respect to criminal laws. And for immigration, you have to satisfy both the federal and the state law aspects to it. So it's a very complex area. And, we do have a team within the Murthy law firm that actually does this kind of work. I know 99% of immigration lawyers don't do that. And it's something you really have to be careful when submitting the 485 to ensure that you obtain, hopefully, just an approval. But if you get an RFE, don't panic. As long as you can show and overcome the RFE, the request for evidence, you should still be able to obtain the approval.
Wow, I'm sure that was a very complex message that you really simplified for all of our viewers, which is brilliant. And I think that's going to be our takeaway this time. You know, this is going to be our golden immigration message for all the viewers watching this space for all things that you say. So this is on this note we end the show, and I hope all the immigrants out there are going to be careful with what Ms. Murthy just said. So thank you, Ms. Murthy. It was, like always, a privilege hosting you.
Honor and privilege is mine always. Everybody stay safe, and we'll see you next week for Thanksgiving week. And we'll continue to count our blessings in life all the time. Look at the positive in life, because life gives us both good and bad, and we can choose to look at the negative and embrace it and learn from it and become smarter and wiser because of it. Thank you, Tony, and thank you to all our audience members.
Thank you, Ms.
Have a
Murthy.
good afternoon.
You're watching Sakshi TV Live with me, Torni Makana. Thank you.